Well, good afternoon, everyone. Once again, I think most of you already know Rose with Mutual of America. I think a good portion of you are utilizing Mutual of America on benefit plans. But talking about compliance, something that is very important for all of us. Rose is going to cover the Secure Act 2.0 and talk about all of the different requirements. As most of you know, the Secure Act 2.0 has mandatory as well as some optional requirements. And it is very important that as you're thinking as to what changes you need to make to your own plans, you need to keep that into consideration. There are a few requirements that are going to be an administrative challenge as to how do you comply with them. And for that reason, we asked Rose to come and really talk to you about how to stay in compliance. A little bit of background on Rose is in that she has 27 years of experience in the field. She joined Mutual of America in their financial group. In see what else I'm getting good. She has worked in prior experience in pension insurance and financial services. She's a FINRA Series 6 and 63 registered representative and holds a life, accident, health, and variable contracts insurance licenses from the state of California. But more importantly, I could go on and on. You can read this about Rose. What I do know about Rose is in that she has taken good care of our clients. And well, I'm sure she's going to be very informative, talking about what you need to do over the next couple of years with regards to the Secure Act 2.0.
Thank you, Roger. Really appreciate that introduction. I want to thank Gil, Roger, and the Vasquez team for inviting me to come out and share some valuable information with the group about Secure Act 2.0. It's not a typo. My legal department wrote it as Secure 2.0 Act, and that is the IRS description. So the common language is Secure Act 2.0. That is commonly known by most individuals as such. My name is Rose Wayman. If you know me well and you can roll your R's, you may call me Rosa. And if you are religious, you can call me Santa Rosa. Now, some important things that we'd like to share with you about Secure Act 2.0 are going to be the following items. So we're going to review some of the provisions that are in effect, and then we're going to review some mandatory provisions, and then a few other provisions that are optional. And then I will leap into how Mutual of America is going to handle that. If you are a Mutual of America client, then we can help you amend your plan accordingly to any provisions that you want to put in place. A little bit of background on the Secure Act. As you all may know, it was signed and put into law back in 2022. And of course, you know how slow the Department of Labor moves and how slow the IRS is about giving us further guidelines. Now, the IRS gave us a ton of provisions to take into consideration as it relates to reviewing retirement programs in general. I'm not going to cover all of them because then you're going to miss out on happy hour. And I want to make sure you're happy today. We're going to cover primarily some of the provisions that affect your employer plans and that affect the employees as well. Primarily, we're going to touch upon automatic enrollment, long-term part-time workers provisions, RMD changes. Those are something that you're all probably more familiar with. Emergency withdrawals, hardship distributions, account portability. This is a new one, and I'm excited because how many of you have terminated employees that just don't move their money, right? So this is going to be an exciting one to talk about. We'll touch upon IRAs briefly, domestic abuse provisions, cash outs, and student loans. And I just realized I'm wearing the wrong glasses because I'm squinting at my camera on the screen. Now, to review some of those provisions that went into effect with Secure Act 2.0, they called it grab bag. And grab bag basically means is that they're going to throw a bunch of provisions in there for employers to review, and you can certainly grab the ones that apply to you or that you wish to amend your plan with. So some of these deadlines, some of the provisions that the IRS has provided to employers to utilize as you see fit. Some of the deadlines are going to be coming up at the end of December 26. Now, a big one that's going to become really handy. I know all of you have, if you have a loan provision in your retirement plan, you've all seen employees take advantage of that loan provision. They take out one loan, they take out two loans, maybe three loans. I've seen as high as 5 loans. And you wonder, how are people surviving if they have that many loans, right? So one of the provisions is going to allow individuals to access some of their retirement money on an emergency savings basis. So they're going to have this little extra pot of money where they can reach in, take out as they see fit. And then, of course, you have long-term part-time employees and retirement plans. There was a time employers were able to exclude some of these employees if they were working part-time. 401k plans typically say if you work part-time, we can exclude you. 403b plans had a tougher time excluding employees because they were eligible under the universal availability provision in a 403b plan. And so going forward, all plans, 403b and 401k plans, have this new provision. If you have any employee who works over 500 hours and they work over 500 hours in a 2 consecutive year, they're going to be eligible to participate in the plan, and they're going to be eligible for an employer match or an employer base or a profit sharing, whatever it is that the employer is providing. Now, corrections, you know, some plans have some overpayment corrections, and employers are going to be able to self-correct. That's something that the IRS is also providing some additional guidance. I don't see a lot of corrections in terms of overpayment. I usually see underpayment more popular. Matching contributions on qualified student loans. So prior to Secure Act 2.0, we were getting the guidelines. We were given some feedback on employers were going to be able to match a student loan. It was thought that the match would go to the student loan payment, but it's actually going to go into the plan as opposed to the student loan program as well. And then, of course, there's the eliminated or stretched IRA program. Anybody who inherited an IRA was able to stretch the payments out for long periods of time, over 10 years. And the new guidelines is suggesting that those payouts need to be complete within a 10-year period. Now, mandatory cash outs, you're all familiar with. You know, it started off with $1,000, it jumped up to $5,000. And now you are able to amend your plan and request any cash outs of any account balances under the amount of $7,000. And this is really going to help employers who were on the cusp of having to do a plan audit on their retirement plan. And if it helps you stay under 100 lives so that you don't have to do a plan audit, that's good news for you. If it doesn't make a difference, then you really don't have much motivation to you know, request anybody to move their money out of the plan in any particular way. Now, depending on the provider, your record keeper, and the provider you're with, some providers do charge if you have terminated employees on books. So it's really important to know what the rule is with your own provider. Do check with your own providers on that particular piece. And the account portability, now, it's not fully in effect because there's got to be some kind of uniform system among all the record keepers in the world of retirement benefits. But basically what they're suggesting is that if you leave an employer and you hire on with another employer, if you have a 401k plan or 403b plan with your current employer, you're going to automatically, when you sign on and go to a new employer, your benefits going to travel with you. And you won't have to do a lot of work to try to transfer over or roll over those assets to the new provider. So I think that's going to be really helpful because I run into a lot of individuals that actually forget that they left money with the previous employer. And then they sign on with the new employer and they're like, I used to have a plan. I used to have a benefit. I no longer have it. I lost track of it. I don't know where it is. I think I lost that benefit because that company went under. And so I really have no idea what happened to my money. So I've helped a lot of people actually find their money. My favorite story is when someone was on the verge of losing their home, helped them locate their money with the cable company when they were working with the cable company, and helped them find their money. They were able to use some of that money to save their home from foreclosure. So it is important to keep track of those monies. This program is going to help individuals keep track of those monies. Not everybody is numbers oriented. Not everybody is focused on what their money is doing for them. I know everybody in this room is, so I'm not worried about you. Now, some provisions that are going into effect in 2025, and if you currently have a retirement plan in place and that plan's been in place prior to 2025, this provision is going to help you continue to run a smoother plan. So new rules on required minimum distributions is really important. Required minimum distributions have new rules. The non-spousal beneficiary required minimum distributions are going to be required starting in 2025. Anybody who has a non-spouse benefit is required to start taking a required minimum distribution in 2025 in order to avoid a penalty. And those penalties right now as high as 50% in taxes. It can be reduced down to about 25% in taxes if you start taking those required minimum distributions in 2025. There is an additional rule that you have to complete liquidating the account in a 10-year period. So it used to be unlimited. You could go as long as you wanted, and that's why they called it the stretch IRA. But now you're required to complete distributions within that 10-year period. There are no RMDs for designated Roth contributions or Roth monies that are in a qualified retirement plan. So if you're an employee and you have a 401k or 403b plan and you're concerned with RMDs, all you have to do is roll over your money into that qualified plan to eliminate the RMD requirements. Now, another mandatory provision required in 2025 is the automatic enrollment for employers that are starting a retirement plan for the first time. With CalSavers, employers are required in 2025 to add an automatic enrollment feature to that plan. Regardless of how many employees you have, you need to start employees saving automatically at 3% of their income. You can auto increase them up to 10%. 10% is the minimal. So employers can go as high as 15, but most employers that I'm seeing, they're going, I'm just going to push them as hard as I can up to the 10 mark that I'm required to do. But after that, it's up to the employee. Just know if you know anybody who didn't offer a retirement plan prior to 2025, this is a new required provision mandated by the Department of Labor and the IRS. So very important to keep that in mind. Move forward in 2025. Now, the following mandatory provision that is required in 2025 is the long-term part-time workers. We touched upon that earlier today, and it is something that employers that have a 403B plan or a 401k plan need to also start tracking. Now, if you decide that you want to exclude employees, you can't exclude them solely based on their part-time status. It is required to identify employees strictly only by hours worked. So the key language in a adoption agreement or plan document is going to be employees who work less than 20 hours can be excluded. They can only be excluded in a 401k plan across the board. In a 403b plan, they can only be excluded from employer matching dollars and employer profit sharing dollars. Huge, huge requirement. Following, we're going to cover some optional provisions, options that an employer can amend their plan for. This is completely optional. And this one's a fun one because I know as people are thinking about retirement and dreaming about retirement, I don't know how many of you are dreaming about retirement yet, but it is certainly exciting to start thinking about what you're going to do, where you're going to live, what your cost of living is going to be like when you start pulling the trigger to retire. I looked at a crazy map not too long ago, and it was really scary to see that if you had $1 million in California, you can live comfortably for about 16 years. But if you live in Texas, you can live comfortably for about 30 years. So that's a huge range, right? So the cost of living is high in California. That's the first thing I learned. And if you were not earning big dollars in your early years, then you're certainly not prepared to retire too soon. And if you had a bunch of kids like I did, I have 3 lovely young ladies in my life that are teenagers, and all I hear is, "Mom, give me, give me, give me." It's a lot of fun, and I jokingly tease my girls, you know, one of these days I'm going to have you off my payroll. But one thing that I will tell you is retirement, if you're dreaming of retirement and you're thinking, can I do more? Can I exceed the IRS limit? Can I do my $23,500? Can I do my traditional catch-up? You can do the traditional catch-up of $7,500 if you're over age 50. If you're under age 50, you cannot. If you're between the age of 60 to 63 and you want to take advantage of the special catch-up of $11,250, you'll need to amend your plan for that specific provision. So if you have any employees that say, you know what, John, Jeannie, I need to, I want to save some more money in my retirement plan. I'm trying to speed up the retirement process. Can you help me with that? The only drawback of that is that once you turn 65, it goes back to the $7,500. So you don't get to double dip. I know my slide says in addition to, but it's not exactly what it means. These slides were written by my legal department, so they don't speak English. But very important to notate that it does revert back to the standard $7,500. Other provisions, and these are really good provisions. I don't know how many of you currently work at a nonprofit, but it's really important to give employees tools, right? These are all tools to help your staff so that they can function, so that they can empower themselves, so they can feel comfortable with how they're going to proceed with their lives. But setbacks happen all the time, right? We're having one right now across our country. I know earlier in the year we had all the fires that were affecting California, and I know a lot of people that lost their homes, and it's devastating to see so much hardship in our community. But some of the fun provisions that you're going to see here is one of them is the emergency distribution we talked about, which is up to $1,000. An employee will have access. And these are provisions, of course, you'll have to amend your plans for. And an employee can take up to $1,000 for an emergency basis from the retirement account. There's one called domestic abuse, and this is unique because I've never ever seen this, but I have run into situations where we receive a phone call from an employee and they're like, I'm going through a very difficult situation at home with my spouse and I need to access money from my retirement account so I can secure myself and my family. Now with this provision, that individual can access no more than $10,000 from their retirement account. They can repay it back over a 3-year period, and they'll be able to self-certify, right? Traditionally, if you're taking out money from a qualified retirement account, you need a spousal consent on that form. And now with self-certification, which is a new rule that's allowing employees to access their money for specific events, they'll be able to touch that money for that purpose. Terminally ill individuals will also be able to access money from the retirement account. This one is going to require a medical certification. So they're going to have to go to their doctor and certify they're terminally ill before they can access money from their retirement accounts, but they'll certainly be able to withdraw any amount available to them in their retirement accounts. And then towards the bottom, you're going to see, the victims of federally declared disaster areas. That's a key one that is helpful to any fire victims. It started way back when with Katrina hurricanes, where a lot of the Department of Labor and IRS started to figure out, we have these very unique situations, and it's happening throughout many places in our country or in our world where people are experiencing major disaster situations. So now employees will be able to access up to $22,000 from their retirement account, and they'll be able to pay it back if they want to over a 3-year period. So very helpful ways to help some of these employees. All these withdrawal provisions are going to be penalty free. So if you ever hear about the penalty that people need to pay if they're under the age of 59 and a half, with these provisions, they get penalty-free withdrawals. So very important. And if someone's wondering why is it down from 100,000 to 22,000, that's because during 2020, during COVID, the IRS had permitted individuals to access up to $100,000 from their retirement accounts and pay it over a 3-year period. Now, looking ahead into the future, we're expecting some changes with Roth in 2026. One of the things that we're going to see is that individuals who normally participate in the catch-up provision, if you're over 50 and you make over $145,000, you are going to be required to deposit your catch-up contribution into a Roth bucket. So if your employer doesn't offer a Roth option in your retirement plan, it is important your plan's ready to receive those Roth contributions. So speak to your providers about ensuring that you're prepared for those new provisions that are going to go into place. Now, fun one, in 2027 coming up, the Savers Credit. Currently right now, lower income individuals usually get a tax credit if they save money in a retirement plan. If a low income person saves $2,000 in a retirement plan, the IRS gives them a $1,000 tax credit if they fall in the 50% tax credit category. Going forward in 2027, the government's talking about matching that person's retirement plan. So that's going to be a fun one too, because I think it's really going to help individuals truly visualize the value of saving for retirement. Because no matter how often we share with them and explain to them that the IRS is going to give them a tax credit on their tax return, they can't visualize a tax credit until they get the refund. And they're like, oh yeah, you're right. I am getting a better refund now. So in 2028, other changes or other programs that are expected to amend their plans, this is really related to collective bargaining plans. So nothing associated with 401ks or 403b, but we threw it in there just for future looking ahead points. Things to expect in the future with Mutual of America. If you're a client of Mutual of America, our goal is to help you monitor and regulate and keep your plan up to date. So if you saw any provisions that you want to amend your plan with, feel free to reach out to me. If you have other providers, feel free to reach out to your other providers so that they can help you amend your plans accordingly to any provisions that you want to put in place with your retirement plans. And then lastly, with our clients, we'll make sure that we provide you with the additional communication and materials that you need to distribute to your employees so that they're familiar with additional provisions that the plan is being amended with. At this time, I'd like to take any questions if anybody has any questions. If, yes, I see one. Go ahead. Uh-huh. Mm-hmm. Yeah, typically, if an employer currently has an automatic enrollment, notices are given to employees. So they're always well aware of what's coming, right? So if you have the provision in place, your provider gave you a notice to give to your staff. And then when they enroll, typically they're also told, we're going to automatically enroll you if you do nothing. But if you do something, you can opt out, you can opt in, you can change your contribution to any percentage you want. And that usually satisfies it. But if you're an employer that currently does not offer retirement planning, you're going to implement one for the first time. Even if you implement one for the first time, let's say July 1st, by law, you are required to give your staff notification. You're going to be automatically enrolled if you do nothing. At the end of the day, they still have discretion to opt out of the whole automatic program. Good question. Anybody else? Don't be shy. And if you are shy, you have my phone number, my email, my calendar. The QR code links you directly to my calendar. You can schedule a virtual conversation with me. We can meet in person. We can have coffee. I'm happy to answer any questions. I'm very active in the community, so you will find me at a lot of events. I attend a lot of galas, golf outings. I golf, so if you love to golf and you want to go out for a day on the golf course, I'm happy to take you out as well. Just want to make sure that I'm making myself available to you to help you provide a better retirement program for your staff. Yes. Good question. It's 101. I haven't broken 100. So it's very handicapped. Yes. Wonderful. Well, thank you so much for your time and your attention. I know that everybody's looking forward to happy hour, and if you're not, have a safe trip home, but I look forward to mingling with you upstairs. Thank you so much.